Online with Terry Jeffrey, a CNSnews.com production.
Hi, and welcome to this edition of Online with Terry Jeffrey. Our guest today is Congressman John Fleming. Congressman Fleming represents the Shreveport area of Louisiana. This is his second term in the United States Congress. He is also a medical doctor in family practice, and as such, he has a particular interest in the health care legislation that President Obama signed last year. The congressman recently led an effort to send a letter to the House Judiciary Committee. Congressman, this letter that you sent, signed by 48 other members of the House of Representatives, called for the Judiciary Committee to, quote, investigate the extent to which U.S. Supreme Court Justice Elena Kagan was involved in preparing a legal defense of the Patient Protection and Affordable Care Act during her tenure as Solicitor General. Why did you put together this group of congressmen and send this letter to the Judiciary Committee?
Well, Terry, it's our understanding through the Freedom of Information Act, Judicial Watch, and others, we've gotten a thumbnail amount of email traffic that suggests very strongly that Elena Kagan, as Solicitor General, was involved in the crafting of a defense with respect to attacks that would ultimately happen on Obamacare and its constitutionality. And however, during her Senate confirmation hearing, she denied having any involvement, and she has thus far refused to recuse should this matter come before her. So we find out that there is an index, quite an index of email traffic that has not been provided to us by the Department of Justice. So we 49 wrote a letter to the Judiciary Committee requesting that we have that information and perhaps others, and in fact they did respond to us.
Congressman, I have to say that the FOIA request was originally filed by CNSnews.com on May 25th, 2010, and the Justice Department sort of was very slow in responding, and around Thanksgiving time, the Media Research Center, which is a parent company of CNSnews.com, filed suit in the U.S. District Court here in the District of Columbia, asking the court to make the Justice Department respond.
Right.
And so far, they've provided us with about 66 pages of email traffic, primarily between Elena Kagan and or her deputy Neil Katyal and some other people in the Office of Solicitor General. There's a great many more documents we're still pursuing. In hope the court will provide them to us. But you've asked the Judiciary Committee to look into this, and I understand that today you actually got a response, or the Judiciary Committee has taken some action on this.
Yes. In our letter, we quote actually Section 455, Title 28 of the United States Code, and it says, quote, where he has served in governmental employment and in such capacity participated as counsel, advisor, or material witness concerning the proceedings, or expressed an opinion concerning the merits of the particular case in controversy, there should be a recusal. And as I said, the email traffic suggests that has not happened. There's much more data out there, much more information DOJ has not provided us. So we did request on June 24th, we 49, and July 6th, Judiciary did respond to us affirmatively requesting that information of Secretary Holder, Attorney General Holder rather, and DOJ, as well as more information and discussions from others who may have been involved in that email traffic.
Right, so the Judiciary Committee, Lamar Smith, who's the chairman, has sent a letter to the Attorney General Eric Holder, who's asking for 4 categories of documents relating to Solicitor General Kagan's tenure at the Office of Solicitor General. He's also asking that the committee be allowed to interview Neil Katyal, who is just now departing as the Principal Deputy Solicitor General, and Tracy Schmaler, who is the Deputy Director of Office of Public Affairs at Justice Department. Are you happy with this response from the Judiciary Committee?
Well, yes, I am thus far. I think it's just the first step. Obviously, the committee does not yet provide the weight of subpoena power. That can't be done without a vote. But this initiates the dialogue and discussion. I'm sure we'll want to wait and see how the DOJ responds. If they do not respond appropriately, we would then urge the Judiciary Committee to move forward with a vote to actually subpoena witnesses and the rest of the information that's not being provided.
And that would require just a vote in the Judiciary Committee, maybe go to the whole House? And
I'm not certain about that. I know it would require a vote in the committee itself. I'm not certain if the entire House would have.
But you think they definitely should subpoena this information if justice?
Yes, if it's not given voluntarily, absolutely, because there is a significant amount of cost and involvement of the many states and citizens in the health care bill that passed and now is law, PPACA, and a lot of people are going to be put at a lot of inconvenience, at a lot of cost, if we don't resolve this issue of whether or not it's constitutional to require citizens to purchase a good or service. And so it's only fair that someone who may have been an advocate for that law should not sit in a position of justice and try to weigh both sides.
So you believe that the American people have a right to know exactly what Elena Kagan said and did when she was President Obama's Solicitor General about the health care legislation?
Most definitely. Yes, absolutely.
And the Judiciary Committee should subpoena that information if necessary?
Yes.
And the Judiciary Committee should subpoena all witnesses who have information about that from the Justice Department?
Most definitely.
If necessary.
Absolutely, yes.
Now, Congressman, you mentioned this law, 28 U.S. Code 455, yes, which governs when federal judges, including expressly justices of the Supreme Court, must recuse themselves from cases. And there are really two prongs to that law. The first part of it says, if their impartiality can be reasonably questioned, then they should recuse. Now, leaving aside the details of Elena Kagan's involvement or non-involvement in the development of a defense of the health care bill, given that she was President Obama's Solicitor General and it was his job to defend his administration's positions in federal court, and she was there when they enacted the health care bill, and she in fact was Solicitor General of the United States and had not recused herself on March 23rd when both Florida and Virginia filed suit against it. Do you think on that basis alone that her impartiality in judging the constitutionality of that law can be reasonably questioned?
Yeah, absolutely. Yeah, without question, without even going further, without even her known involvement. Just simply the fact that she was heading that office that had that responsibility would certainly shed a lot of gray area and concern about that possibility.
So in your mind, that alone she should recuse under the terms of the law?
Yes, absolutely.
And given that the House Judiciary Committee has oversight over the courts, and also has oversight over this specific law, you believe that they should probe that question too?
Yes.
And come to a determination of whether that's the case?
Right.
Do you in the letter that you and the 48 other members of Congress signed, you did suggest that you believe that she had already triggered the recusal threshold.
Right.
So you're understanding that the other 48 members who've signed with you, they share your view that this first prong of reasonable judgment, she's already passed that?
Yes, that is my understanding, that all 49 of us agree on that point. And certainly all you have to do is to go to some of the example emails where she actually encourages those under her to keep her in the loop, to involve her, to not do anything in effect without her involvement and perhaps decision making. That alone, I think, triggers that wire.
Okay, now the second prong of the law is that it says when a justice of the Supreme Court was in prior government service, if they were a counselor or advisor or an expressed opinion as to the merits of a particular case in controversy, they would then have to recuse. Now, my understanding of the emails from my reading of them is there isn't any place there where Elena Kagan has personally in writing expressed an opinion on the merits of the litigation against the Obamacare bill. However, it's pretty clear that she did assign Mr. Katyal to deal with the issue, her deputy. She did have a telephone conversation with him the night that the bill passed the House of Representatives, March 21st, and she was his boss during that time.
Right.
Do you believe that one target of this Judiciary Committee investigation should be to find out what actual communications Elena Kagan had, verbal as well as those that are in writing, pertaining to the health care bill?
Yeah, definitely. Anybody who was that involved in the email traffic in communication with her and being a close deputy, it'd be essential to have that person's testimony.
Two key moments, at least from what we know from this chain of emails. On January 8th, 2010, which is about 2 weeks after the Senate passed the health care bill, which happened on Christmas Eve of '09, a person named Brian Houck in the Associate Attorney General's office sent an email to Neil Katyal, who's the Principal Deputy Solicitor General, and he essentially said, look, we're going to put together a group to plan the inevitable defend against the inevitable challenges to the health care bill, and we need to know who's going to get involved in your office to start this rolling. Katyal emailed back immediately to Houck and said, absolutely right on, let's crush them. In other words, he said, let's crush. So he clearly had a view about the legal and constitutional merits. And he was her principal deputy. Now, Congressman, in that same email chain, without sending to Kagan the email he sent back to Houck, Mr. Katyal sent to Kagan an email saying that he would like to do it, to be involved in planning against the challenges to the health care bill, although Ed Needler, another person in the office, might do it too. And she emailed him back and said, you should do it. And then a little bit later that day, in fact, after the lunch hour, Katyal emailed back to the Associate Attorney General's office and said, Elena definitely wants our office involved, and that he would bring her in as needed. Do you think the Judiciary Committee needs to bring Mr. Katyal in, and among other things, ask him whether he specifically had a conversation that day, January 8th, 2010, with Elena Kagan about the potential health care litigation?
Yes, most definitely.
And do you suspect that he probably did?
Well, one can only infer that in transmitting his phone number, in the conversation back and forth on email, here's my phone number, let's talk about it.
Right.
One must infer that a phone conversation must have followed up to that email traffic.
Right. On March 21st, the day that the House passed health care legislation, on that day there was another email from the Associate Attorney General's office talking about a meeting that would take place the next day at the White House. And Katyal emailed to Kagan and said, you should go to this meeting now. She emailed him back and said, what's your phone number? He emailed her phone number.
Right.
You think the Judiciary Committee should probe?
Yes.
What exactly was the conversation they had on that day?
That's a critical point in time, a critical conversation that most likely occurred, and we would need his testimony to know if, in fact, it did occur.
And there were other people when the Justice Department responded to this FOIA request, which CNSNews.com put in. They eventually only checked 3 files, they said. They checked the email files of Elena Kagan herself.
Right.
They checked the email files of her confidential assistant, and they checked the email files of Mr. Katyal.
Right.
They did not check the files of the other deputy solicitor generals.
Yes.
Do you think that the Judiciary Committee should look to see if there's anything in the files of her other deputies?
Yes.
To see?
Absolutely.
Another thing, Congressman, is in the questionnaire, or in response to questions from the Senate Judiciary Committee Republicans, who asked her 11 questions about her possible involvement in the healthcare suits. And they also asked her these generic questions about whether she had ever asked or whether she'd ever offered or ever been asked her opinion about the underlying legal and constitutional issues of the healthcare bill President Obama signed and litigation or any other healthcare proposal. And she said no. And she did say that she did attend a meeting where at least the existence of the healthcare bill, healthcare litigation, was discussed. Do you think it's imperative that the Judiciary Committee find out exactly what that meeting was and what was discussed?
Yes, most definitely.
She also said that she had attended the Attorney General's morning meetings up until sometime in April, which would have meant until sometime after Virginia and Florida filed their lawsuits on March 23rd of 2010. Do you believe the Judiciary Committee should demand that the Attorney General's office turn over any records of any meetings that she attended, one way or the other, with the Attorney General where the health care bill was discussed?
Yes, I do.
Do you believe it's possible that in the Attorney General's meetings from December 24th, when the health care bill passed the Senate, through to May 10th, when she was nominated to the Supreme Court and recused herself, do you think it's possible that they never talked about the potential health care litigation or the actual health care litigation in those meetings?
I don't see how they could have avoided that discussion. I mean, again, we find out through this Vaughn Index that there must have been probably hundreds, if not thousands, of email traffic throughout, in between the Solicitor General's office, DOJ, and other governmental offices. Obviously, it was a hot topic. It was discussed a lot here in Washington and elsewhere. So every sign would suggest that that must have been on the topic of discussion very frequently.
In your conversations in working with the 48 other members who signed this letter, Do you sense that they are absolutely committed to making sure that these answers come out before the Supreme Court actually hears that case and makes a
Yes,
decision?
absolutely, yes.
Have you been able to have any conversations with the Republican leadership about this issue?
I have not at this point.
Okay. Is there anything else you'd like to say about your efforts?
Well, that I think that even though 49 of us signed this letter, I think the sentiments and interest and beliefs many more members, at least on the Republican side, are for us to move forward. And I suspect that we'll probably in the coming days hear more from them. So I think that it's important that we resolve this issue about constitutionality, but we need to do it fairly. As I say, this is a critical point in history in our country, and I just don't think it's appropriate to allow a single justice to be in the court deciding this when they may have at some point be an adversary for or against this legislation.
So your anticipation is if Chairman Lamar Smith has to move forward and actually subpoena the Attorney General and subpoena the Office of Solicitor General's office to get the documents and testimony they need to find out what went on here,
Yes.
that the Republican caucus as a whole in the House of Representatives will be supportive of that?
Of course, I can't speak for each and every individual, but I would say the majority would, and I would not be surprised if all did.
Congressman, thank you very much.
Great. Thank you, Terry. Always a pleasure.